morning. The Senate Judiciary Committee meeting will come to order. And our first order of business is to really announce that we are on WebEx today. The Senate President announced in the Senate chamber yesterday that for today, only March 10th, 2022, that we would be able to hear bills via WebEx, whether we are in the state capitol building or not. So with that, we will open the hearing on House Bill 2473, removing the requirement that all district court judges in Douglas County serve on the Board of Trustees of the Law Library. And we'll ask for a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair, and good morning to everyone on WebEx and a couple of people here in the room. House Bill 2473 is a bill that removes the requirement that all district court judges in Douglas County serve on the Board of Trustees of the Law Library. The bill is amending KSA 20-3127, which is the statute concerning county law libraries. And current law allows the Board of Trustees of a law library in Johnson County and Sedgwick County to be made up of 2 district court judges and 3 members of the county's bar association, but requires the Board of Trustees of a law library in any other county to be made up of all the district court judges in that county and no fewer than 2 attorneys in the county. So the bill would apply the provisions that currently apply only to Johnson and Sedgwick County to Douglas County, so that not all judges have to serve on the board in the Douglas County Law Library Board of Trustees. Be happy to answer questions.
Thank you, Mr. Thompson. I'm looking at the bill and it looks like I think you said it removes the requirement that 3 members be Johnson County or Sedgwick County as well.
Madam Chair, Jason Thompson again. So the current law says that in Johnson County and Sedgwick County, 2 judges and 3 members of the bar are on the Board of Trustees of the Law Library. And this just makes Douglas County subject to that same provision. So the only change is for Douglas County, not for any other county.
Thank you for clarifying that. Committee, any other questions for the reviser? Seeing none, then we will invite our proponent conferee, Judge Mark Simpson from, I'm sorry, I don't have your full information. I think the testimony was recently submitted. I think a judge in Douglas County, if I'm correct. Please introduce yourself so we get it right. Thank you.
Yes,
Welcome
thank you. I
committee.
appreciate that. Good morning, Chair Warren and ladies and gentlemen of the committee. My name is Mark Simpson. I'm a district court judge in the 7th Judicial District, which is Douglas County, as you know. Thank you for taking a little bit of time to consider this bill. The goal of the bill, it's a very narrow change, but the goal is really just to allow us to be a little bit more efficient in how we use our time by not requiring all 6 of the Douglas County District Court judges to serve on the Law Library Board. You all probably know better than anybody else that any meeting you take part of is time you couldn't spend on something else. I'm sure that applies to you even more than it does to me. And I think it's important that there's judges on the Law Library Board, but I don't know that it's adding a whole lot of value to have all 6 of us serve and be at every meeting. So basically what the bill does, as you've heard, is just allows us to use the same rules that apply to Johnson and Sedgwick County. So there'd be 2 judges on the board, on the library board, as opposed to all 6. So it's a small change. The idea is just to make things a little bit more efficient. And we also, the idea is that it would be a very narrow change. It applies to Douglas County. And the only reason that it only applies to Douglas County is because really didn't want to change the way other folks were doing it if they didn't want it changed. So that's the reason for that. But I, again, appreciate your time and your consideration of the bill. And I'm happy to answer any questions too, if any of you have any.
Thank you. Before we get to questions, are there any other proponent conferees in the committee meeting room or on WebEx? I don't see that we have any. So with that, any questions for our conferee, Judge Simpson? I have just a couple questions, Judge. Thank you for being here. And tell me what kind of considerations the judges are looking at when they serve on the Law Library Board. What kind of issues come before the board?
So it's a very practical business board where there's a room in the courthouse that's the law library. There's some desks, there's some computers. The issues that have come before the Law Library Board since I've been on it for the past couple of years are things like hiring of a part-time law librarian, approval of a law library budget, what cable provider to use, things like that. So there aren't any large policy type decisions. It's sort of a nuts and bolts of operating a law library.
I've been in many of those over the years, but thank you for your service on the board. Committee, any other questions for Judge Simpson? Seeing none, then are there?
Madam Chair?
Yes.
Senator Gossage had her microphone unmuted. I was unsure if she had a question.
I do have a question. Thank you. I wasn't sure if you'd be able to see my hand raised. In earlier committees, we haven't been able to do that. Are you able to see a hand raised?
Senator Gossage, I don't see a hand raised, but maybe if you start your video, that might help. But in any event, if you don't want to start your video, you have the floor, Senator.
Okay, thank you very much, Madam Chair. I'm sorry, I was having difficulty getting in, so I was about 2 minutes late. So I did not hear how is it that, so it's only Douglas County, and how is it that they are different than everybody else? So forgive me if somebody's having to duplicate.
Go ahead, Judge.
Sure. So the way the law library statute is written now is the Johnson County and Sedgwick law libraries just require 2 of the district court judges to serve on their board. And then everybody else, all the district court judges in that county serve on the law library board. So there's already a little bit of a difference in how things are set up. And I think that practically a lot of this doesn't apply because if you think about how many counties have a law library and more than 2 judges, there are some, but not that many. So really that's what the point of the bill is just to sort of acknowledge that maybe we shouldn't have all 6 of the judges attending every one of those meetings. So that's the reason. It's really a population-based thing. And then I think practically in smaller counties, there's not necessarily a need to change because there's not more than 2 judges, if that makes sense, Senator.
That does make sense. Thank you very much. Thank you, Madam Chair.
Thank you. Committee, any other questions? I'm not seeing any, but if Mr. Nicholson, our AV tech, sees any, he'll let me know. And do we have any neutral or opponent conferees in the committee meeting room or online? Not seeing any. Then I will thank our conferee, Judge Simpson, for appearing today and for your time and your testimony. And we will close the hearing on House Bill 2473. And we will then turn, thank you. We will turn to opening the hearing on House Bill 2508, requiring retention of fingerprints by the Kansas Bureau of Investigation for participation in the federal Ratback program. And ask for a bill brief from the revisor, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. And I forgot to mention the procedural way that the bill got to you last time, which I'll do on this bill. But on the last bill, just for purposes of being clear, that was introduced by Representatives Heiberger and Neely, passed out by the House Judiciary Committee, and passed the House 121-0. So if you needed that for your notes, there you go. For the current bill, now House Bill 2508, it was requested by Representative Patton on behalf of the Kansas Bureau of Investigation. It went through the House Judiciary Committee, and it passed the House 115-6. So the bill is requiring retention of fingerprints by the KBI for participation in the federal Ratback program, and that program is described in a definition of in the bill. Essentially, it's a system that enables an entity to receive ongoing notifications of criminal history record updates for folks who have had their fingerprints submitted for a record check. So the bill would enact a new section of law that requires an applicant, employee, or volunteer who is subject to a record check, a criminal history record check, to provide the requesting authorized entity with a consent to obtain their fingerprints so they can conduct that record check and then participate in the Ratback program to determine their suitability or fitness for a permit, a license, volunteer service, etc. So the authorized entity is required to notify each person that's going to be subject to a record check that the fingerprints shall be retained by the KBI and the FBI for all current and future purposes authorized. And then when fingerprints are going to be enrolled in the Ratback program, they're also supposed to notify the person of that. Fingerprints are searched against known criminal fingerprints to determine if there's a criminal history record. And it's also searched against latent fingerprints entered into the unsolved latent fingerprint file. The record check is only completed for the purpose for which it was requested, so to determine fitness or whatever other purpose is given. Additional record checks require submission of a new set of fingerprints, so it's a limited scope for each submission. And then an authorized entity enrolled in Ratback shall immediately notify the KBI when the entity is no longer entitled to receive that criminal history record information relating to a particular person. And when the KBI gets that notification, they cancel the enrollment and cancel updates of history information to that entity that's no longer entitled to receive it. The last thing I'll note is that the fingerprints and the records acquired by the KBI are, of course, only available to authorized entities, and employees of the KBI are not allowed to disclose those records to anyone not authorized by law to receive them. And then I noted at the beginning there's a definition of Ratback, but there's also definitions of authorized entity and criminal history record check. Those are very particularized terms. There's a number of laws and regulations governing the criminal history records and who is allowed to obtain them. So that's kind of what those definitions get into. And I'll be happy to answer any questions, and note that the KBI representative is here to testify, so hopefully more technical questions would be appropriate for them.
Thank you. And I see Mr. Nicholson has his hand raised. Mr. Nicholson?
Yes, thank you, Madam Chair. I know that there are some senators that are, and maybe some other conferees that are on WebEx connected to their phone. If you wish to raise your hand, there should be a three dot option. If you click that, that should open up a raise hand option just to help anyone that wanted to ask a question.
Great, thank you. Committee, any questions for the revisor? I have a question. This is not amending current law as I'm looking at the bill. Do I have that right? So this would be a new program, or at least new in law. We're not amending a current statute. Is that correct?
Thank you, Madam Chair. Jason Thompson again. That's correct. This is a new section of law. There are, of course, a number of statutes governing criminal history record checks and a number of statutes that require fingerprinting to obtain those record checks. But this is an additional statute that I think the KBI will explain is sort of necessary to implement the ongoing use of the Ratback program and the ability to get continual updates of criminal history record information rather than just the one-time check on the front end before you employ someone or allow them to volunteer, etc. This allows the ongoing process.
Thank you. Committee, other questions for the revisor? Seeing none, then we will go ahead and invite our proponent conferee, Robert Jacobs, Executive Officer, Kansas Bureau of Investigation. And I think he's in the committee meeting room. So thank you for coming to the Capitol and appearing in person. I tried to traverse the roads and get to the Capitol, but it was coming down and is coming down pretty hard. So thank you for the effort, Mr. Jacobs, and go ahead and introduce yourself and welcome to committee.
Thank you. Good morning, Madam Chair and members of the committee. My name is Robert Jacobs. I am the Executive Officer at the Kansas Bureau of Investigation. I appreciate the opportunity to come today and speak with you as a proponent on House Bill 2508. I want to try and maybe clarify some things right off the bat. The reviser, Mr. Thompson, did a great job of explaining the bill. But first off, I'd like to explain what Ratback means. And that Ratback stands for Record of Arrest and Prosecution. And then back is the latter part of that. So when I did this with the House, I think I confused them more than I hoped. So what I'm going to try and do to start today is actually start with an example, because I think that will really help illustrate what we're trying to do with this bill. So currently there's about 80 statutes on the books that allow for civil retention or civil fingerprints to be collected in order to do a record check. And when we do a record check, we're looking at an individual's criminal history. And so, but as Mr. Thompson stated, that is a snapshot view of what that criminal history is at that moment that request occurs. So, for example, an individual receives an RN degree from a university and decides to apply for a license to be a registered nurse through the Board of Nursing. The Board of Nursing, through statute, requires that individual provide their fingerprints to the Board of Nursing, who then turns those over to the KBI and requests a criminal history record check. What we provide the Board of Nursing that criminal history record check, and that would give them a view of what that person's criminal history is at that moment. The Board of Nursing then has the option to enroll that person in what's called Ratback. Ratback would then, the Ratback system basically then enrolls those individuals' fingerprints in a database that in essence continues to monitor if there's any updates to that person's criminal history. So if that person then is arrested at a subsequent time and their fingerprints are taken, then that entity or the Ratback system would match those fingerprints from that arrest to the individual's fingerprints in Ratback, and then make a notification to the Board of Nursing that individual has had a change to their record, their criminal history record. Before that notification is done, the KBI and both for what our current Ratback system will notify that Board of Nursing and first determine whether or not they're still eligible to receive those fingerprints and those change in record. So if that person subsequent time has already left Kansas and is no longer with the Board of Nursing or licensed in Kansas, the Board of Nursing would then notify the KBI, no, we are not eligible to receive that criminal history report, and we would not disseminate that report at that time. So that's in a nutshell how the Ratback system works. What I'd like to talk to you now about is what 2508 will do. And 2508 looks to do primarily 3 or 4 things. One, it will clarify in statute what the Kansas Bureau of Investigation is already doing by retaining civil fingerprints. We currently already do that. We've had legal opinions in the past that have said that we can do that. And we would just want to put it in statute telling people that we are doing that. But more importantly, this bill was designed so that the individual who is applying and providing their fingerprints to an authorized entity, whether that's Board of Nursing, Department of Education, DCF, there's all of these different ones, that those entities are required to notify that individual that, number one, their fingerprints are being retained by the KBI, and the FBI, sorry, and that number two, they are required to notify them that they are actually enrolling that individual in the Ratback system. So, and then finally, the third piece to that is that the authorized entities are according to 2508, if we can get this through, will be required to notify the KBI once an individual has left association with that entity, whether it's Board of Nursing or they're no longer licensed or an employee or a volunteer through that entity. They were required to tell the KBI so that we can remove that individual from Ratback, and so that we don't have that individual in Ratback anymore. There are multiple criminal justice and non-criminal justice entities that are entitled to fingerprint criminal history checks. I named a few of the non-criminal justice ones, such as DCF and Department of Revenue, and then Board of Nursing, Department of Education. Some of the ones that are criminal justice ones would be sheriffs, candidates, chiefs of police, chiefs of police, and certifications through KLETC, as well as KC Post, the ability to do police officer standards and training. The reason that we are bringing this bill together, or to the legislature this year, is that currently in Kansas, our current AFIS system, which is the Automated Fingerprint Identification System, will only allow us to do Ratback for arrests that occur in Kansas. We don't have the technology to be able to look at arrests that are done across the United States. However, in 2020, the legislature provided funding to the KBI to purchase a new and replace our AFIS system with a new Automated Biometric Identification System, or ABIS. ABIS will have the capability to allow our authorized entities to receive information on arrests of people who they enroll in federal Ratback, where arrests are made across the United States. And these are arrests and convictions. So the FBI has told us that the only way that we will be eligible to participate in the FBI Ratback would be to change our statutes to make sure that we are notifying people that they are being enrolled in Ratback and that we are retaining their fingerprints. The good thing about the federal Ratback system is that currently, when an individual applies to become let's say a teacher, they have to submit their fingerprints. That is a $47 charge, and that pays for, part of that pays for the state record check, and part of it pays for the federal record check. And once their certification is renewed, or up for renewal, which is typically about every 3 to 5 years, they have to again pay another $47, submit a new set of fingerprints, and the whole system and the whole process starts again. We do a new record check, and then it goes on. With the federal Ratback system, those would be continuous, so that need for a renewal of fingerprints every 3 to 5 years would go away. So it's a cost savings to the individual as well. And again, we believe that this will allow those entities that are hiring and whether volunteers or licensing individuals who may be dealing with vulnerable populations, it would allow them to be notified that there's been a change to an individual's criminal history sooner rather than later. So it is a safety valve for allowing entities to make decisions on the employment or volunteer status or licensing of an individual based on their criminal history. Remember, these are all done based on arrests and prosecutions. So with that, we appreciate the committee's time, and if I'd be happy to stand for questions.
Thank you, Mr. Jacobs. Appreciate that thorough testimony. Committee, questions for Mr. Jacobs? Yes, Senator Gossage. You're still muted, Senator.
Now you can hear me, right?
Yes.
When you say that the a new crime has been committed and then that would be sent forward. We're not just talking about things like somebody got a speeding ticket,
It
right?
would, yeah. Thank you, Senator Gossage. This is Robert Jacobs again with KBI. You are correct. These would be crimes that, number one, would end in an arrest. So it would have to be an arrestable crime and or a conviction. The other thing to remember is that each of these entities, these authorized entities, Board of Nursing, all the others, they have certain disqualifiers that they are that they use this criminal history information for. So if an individual has a theft and is arrested for a theft, that may not be necessarily one of the disqualifiers for, and I'm just using this as an example, Board of Education, a license to be a teacher. That may not be a crime that would necessarily disqualify them. And so that crime, that arrest may not be provided back to Department of Education on those certain ones. It's only on the ones that the entity has determined to be a disqualifier or a crime that they would like to be notified of.
Thank you, and thank you, Madam Chair.
Thank you. That raises a question for me, and I understand and appreciate the intent of the bill. So if I'm correct, any arrest, not a prosecution and not a conviction, but the act of the arrest would be reported to the licensing agency or the other authorizing agent or the other authorized entity. Is that correct?
If it falls into what they're allowed to have, yes. And they're not allowed to have all of them. It's just certain crimes.
So with the authorized entity that is authorized to have information about convictions for certain types of crimes, would the arrest of the individual licensed by the authorized entity, would that arrest be sent to the authorized entity? Not the conviction, but the arrest.
Yes, ma'am. So the notification system is based on both arrest and prosecution. The arrest is a public document at that point. So it is only sent to that one entity, and whether that entity determines to act on that or not is up to them. But it's a notification process.
And already the authorized entities, if they desire, they could go search the public records, the public record of the arrest, correct? Without this bill.
Yes, ma'am. Robert Jacobs again with KBI. Yes, that is my understanding. They could do a public search for that arrest because the arrest would be public record.
And sometimes these arrests don't lead to prosecution and they don't lead to conviction. I mean, that's just kind of stating the obvious, right?
Yes, ma'am. I would assume so, yes.
Okay, thank you. Are there other questions from the committee for Mr. Jacobs? I'm not seeing any, but want to make sure I'm not missing any. So I don't think we have any then. So with that, do we have any other, want to thank you, Mr. Jacobs, for appearing at the Capitol today and for your very thorough testimony and for bringing this to the legislature.
Thank you again, Madam Chair.
You bet. Thank you. Do we have any other proponent conferees in the committee meeting room or online? Not seeing any. Do we have any neutral or opponent conferees in the committee meeting room or online? Again, not seeing any. So with that, then we will close the hearing on House Bill 2508. And with that, committee, we will conclude our work for today. Thank you to everyone for who was able to join online. Appreciate that. And we will see each other at the next meeting. Thank you very much, and we are adjourned.